You know, usually when you think about a building inspector, there's like a very clear expectation of what their job actually is.
Right, yeah. They show up, they check if the wiring is safe.
Exactly.
Hmm.
They make sure the foundation isn't cracking, they look at the pipes, and they sign off. It's essentially this, you know, binary job, like code or no code.
It's a comforting dynamic, honestly. I mean, you want someone checking the structural integrity. You definitely don't want them questioning your taste in wallpaper or telling you how to arrange your living room furniture.
No, definitely not. But imagine if that building inspector walked in, looked around, and suddenly decided, well, actually, open concept living rooms are bad for family dynamics.
Oh, wow.
Right. So they just say, I'm going to redraw your blueprints and mandate a completely different floor plan.
Yeah, that's wild. They aren't just inspecting the building anymore at that point.
Exactly. They're engineering your domestic life. They're deciding how your family should interact.
They've moved from, like, checking the rules to actively designing the culture of the house itself.
Well, welcome to the deep dive. We know you are here because you want to understand the deeper currents driving today's headlines.
To get past the noise.
Yeah, to find out what is actually holding the structure up. Or, in this case, redesigning it entirely.
Right.
So today, we are unpacking an incredibly thought-provoking excerpt from the book The Legal Philosophy of the Common Law by Yang Kang.
It's a fascinating read.
It really is. And specifically, we are looking at a case study titled, Where Exactly Do the Problems of the U.S. Supreme Court Lie?
Which is quite the title.
It sets the stage, right? And our mission for this deep dive is to explore Kang's central, rather provocative thesis.
And what is that thesis exactly?
That over the last century, the United States Supreme Court fundamentally transformed its own role. Like it went from being a passive referee to an active engineer of public culture.
Okay, so before we really get into the mechanics of how the court pulled off that transformation, we definitely need to establish some ground rules for you, the listener.
Good idea.
Because the source material we are diving into touches on some highly charged topics. I mean, we're talking religion, secularism, the separation of church and state, constitutional law.
Heavy stuff.
Very. So we want to make it explicitly clear right up front that we're not taking any political sides here.
Right. No right or left.
Exactly. We are not endorsing a specific viewpoint. Our goal today is purely to unpack the fascinating legal, historical, and philosophical arguments presented in the author's text.
We are exploring the architectural critique of the system. We're not telling you who to vote for.
Perfectly said. We're just looking at the blueprints.
So to see where these blueprints started to change, we have to look back. We are going to post-World War II America.
Okay, take us back.
Because to understand this transformation of the modern Supreme Court, we really have to follow a very specific, decades-long chain of cases regarding public schools.
Right. And looking at the American legal tradition, the founders established the Supreme Court to be this guardian of individual rights and an arbiter of disputes between branches of government, like a passive adjudicator.
You bring a specific dispute, they settle it based on the law. Simple.
Exactly. But the text argues that starting after WWII, the court shifted out of that passive posture.
It started doing what?
They began actively shaping public order. And the battleground they chose for this was the public school system.
And the evidence the author uses for this is just staggering when you look at how these cases built on each other.
Oh, absolutely.
It's this chain of precedents spanning from 1948 to 1992. And the author actually categorizes this entire era as the, quote, de-Christianization of public schools.
Which is a strong phrase. So let's look at the actual history there to see what he means.
Yeah, let's break it down. So in 1948, you have the McCollum case. The court strikes down a program called Release Time.
And release time was, what was that
It
exactly?
was a system where students could get religious instruction during the school day on public school property if their parents opted them in.
Okay, so purely optional.
Right. But the court said, no, you can't use state property for that.
Wow. Okay, then you jump forward to 1962, which is the Engel case. And this is a massive turning point.
How so?
Well, the New York Board of Regents had actually composed a very generic, non-denominational prayer for students to say at the start of the day.
It's a generic prayer.
Yeah. And the state's argument was that it was totally voluntary. I mean, if a student didn't want to participate, they could sit quietly or just leave the room.
Seems pretty accommodating.
But the court ruled that even a voluntary, non-denominational prayer sponsored by the school violated the Constitution.
Wow. Which totally set the stage for 1980, right? The Stone case.
Yep, 1980.
Where a school put the Ten Commandments on the wall, just on the wall,
Yeah.
And the court ordered them taken down.
And it keeps going.
Yeah.
Because then in 1985, you have the Wallace case.
Right. That's when schools tried to pivot, right?
Exactly. They thought, okay, what about moments of silence for meditation or voluntary prayer?
Just silence.
Just silence. But the court struck that down too, looking at the intent behind it.
Unbelievable. And finally, in 1992, Lee v. Weissman, they outright outlawed school-led graduation prayers.
So notice the trajectory here. It wasn't just a single ruling fixing a single isolated problem.
Right. It's a pattern.
It was the gradual, deliberate construction of a brand new framework of constitutional interpretation.
So the text is arguing that these cases collectively defined public schools as these highly secularized state spaces.
Exactly. Effectively quarantining religious expression.
You know, it really makes me think of sports again.
Go on.
Like, it sounds like the author is saying the court went from being an umpire simply calling balls and strikes on a specific pitch
Right.
to acting like the league commissioner,
Yep.
like actively rewriting the rule book to change the entire culture of the sport.
That umpire analogy captures the dynamic perfectly. The court moved from saying, does this specific isolated action violate the text of the Constitution,
Right.
to basically prescribing what exact place, if any, religion should occupy in the American public sphere.
But how did they actually do that? Like, logistically. If the court fundamentally changed its role, what was the legal logic they used to justify that shift to the American public?
Well, according to the text, the court relied on a specific judicial toolkit.
Okay, what's in the toolkit?
It contains three main mechanisms. The first was an incredibly expansive interpretation of the Establishment Clause.
Okay, so the First Amendment says Congress shall make no law respecting an establishment of religion.
Exactly. And historically, that meant preventing a literal national church. Like, you can't make everyone become an Anglican.
Right, you can't force a state religion.
But the court expanded that to mean banning basically any government endorsement of religion whatsoever.
I see.
And because public schools are funded by the government, the school is viewed as an extension of state power.
Just the local classroom basically becomes a federal organ.
Yep.
So if a teacher leads a prayer, it is legally treated as if the President of the United States is telling you how to pray.
That's exactly the logic. And the second tool is what the text calls the captive audience or coerced presence logic.
Captive audience. Okay.
Basically, the court began treating students fundamentally differently than adults.
How so?
Let's look closer at that 1992 graduation prayer case, Lee v. Weissman.
Right, the graduation one.
The school argued that attending graduation is entirely voluntary. No one is forcing a student to be there.
Which is true.
But the court argued that the social and institutional pressure to attend your own high school graduation is so immense.
Oh, I see where this is going.
Yeah, they said that to ask a student to stand there quietly while a rabbi or a minister prays exerts what they called de facto coercion.
Wow. So they redefined coercion from, like, physical force or legal penalty into psychological pressure.
Exactly. The court essentially ruled that forcing a student to choose between attending a major life milestone and listening to a prayer they disagree with is a form of state-sponsored psychological trauma.
Okay, so if they expand the Establishment Clause and they redefine coercion to include peer pressure, what happens when a school just says, hey, we are putting the Ten Commandments on the wall purely for historical reasons? Like, it's a historical document.
Well, that brings in the third mechanism, which is purpose scrutiny.
Purpose scrutiny.
Right. The court started looking past the actual text of the laws to invalidate them if their primary intent was identified as religious.
So reading their minds, basically.
Sort of, yeah. In the Ten Commandments case, or those moment of silence cases, local states tried to argue their purpose was totally secular, like for history or just quiet reflection.
Right.
But the court scrutinized the legislative intent. They effectively put lawmakers on the psychological couch. And they said, no, your hidden primary goal here is to advance religion. Therefore, it violates the First Amendment.
Man. Okay, I have to play devil's advocate here for a second, though.
Go for it.
Because if I'm listening to this, I might be thinking, wait, isn't neutrality exactly what we want in a public school?
The fair question.
I mean, a school is funded by taxpayers of all faiths and people with no faith at all. We don't want a school forcing one specific religion on everyone. So why is the author framing this push for neutrality as a problem?
Well, what's fascinating here is how the author dissects that exact word, neutrality.
Okay.
The text makes a crucial distinction between two types of neutrality. There is procedural neutrality, and then there is substantive neutrality.
Break that down for us. What does procedural neutrality actually look like in a school?
So procedural neutrality means the state doesn't coerce anyone and it doesn't discriminate.
Right.
It allows diverse faith communities to peacefully coexist. Imagine a public school letting a Muslim student group, a Christian student group, and a secular student group all use vacant classrooms after school.
So they all get space.
Exactly. The school isn't endorsing any of them, it's just playing traffic cop to make sure the cars don't crash into each other.
That makes sense. So what is the other one? Substantive neutrality.
Substantive neutrality is very different. That is when the state maintains a completely value-empty stance and treats religion as something that must be exclusively private.
Oh, wow. Well,
The state dictates that the public square must be stripped of any religious footprint. To use your analogy, the traffic cop isn't just managing the intersection anymore.
right.
The cop is saying that certain types of cars are fundamentally unsafe and aren't allowed on the road at all.
Wow. So the author's arguing the court imposed substantive neutrality.
Yes.
They didn't just forbid a teacher from forcing a kid to pray. They excluded anything that might even look like state recognition of religion.
Exactly. And the text argues that isn't actually neutrality at all.
No, doesn't sound like it.
It is a very specific secularist interpretation being forced onto the public as a constitutional mandate.
And by enforcing this specific flavor of neutrality, the court had to have triggered a massive ripple effect.
Oh, a huge one. If you pull a thread that big out of the tapestry of American society, the entire structure shifts.
Right.
And the text actually identifies 4 major structural fallouts from this judicial activation.
Okay, so let's go through them. The first one the author points out is interpreting the phrase separation of church and state as a mandate to completely purge religion from public life.
Which was never the original intent.
Right. The original design of that phrase was to limit governmental power, to keep the state from running the church. It was never designed to scrub religious resources, vocabulary, and history entirely from the public culture.
Exactly. And if you force that complete purge, if you mandate substantive neutrality, you inevitably create a de facto anti-Christian bias in the culture.
That's the second fallout, right?
Yes, because by ruling that public spaces must be completely secular, secularism stops being a neutral playing field.
Right.
It becomes the new invisible civil religion. It becomes the default orthodoxy that everyone is forced to obey the moment they step out of their front door.
Man. So if secularism becomes the new mandated religion of the public square, what happens to the local towns that don't agree with that?
Well, that's the third fallout.
Because if a local town in Nebraska and a local town in Massachusetts have completely different community values, they used to be able to reflect that in how they ran their local schools.
Right, but under this new framework, they lose control. The author highlights the destruction of local self-government as a major consequence.
Because historically, public schools were deeply tied to local parent communities.
Exactly. Those communities negotiated their own public culture. They worked out compromises face-to-face.
But this chain of Supreme Court precedents nationalized the whole issue.
Yes. Local parents lost the space to negotiate. It was replaced by nationwide, zero-sum constitutional warfare.
You can really see how this heavily distorted the First Amendment itself.
Which is the fourth error, the author points out.
Right, because you have the Establishment Clause, which says the government can't establish religion. But right next to it is the Free Exercise Clause, protecting your right to actually practice your faith. And the text argues the court massively expanded the idea of establishment while severely compressing free exercise.
Exactly. The message sent to the public was basically, you can believe whatever you want privately in your head.
But keep it at home.
Right. The moment you step into a shared public space like a school, your faith must be hidden so it doesn't violate the Establishment Clause.
So it compresses faith from a comprehensive communal way of life into a mere private preference.
Spot on.
You know, I want to pause here and connect this directly to you, the listener,
Good idea.
because you might be sitting there wondering, why does a string of school prayer cases from the 1960s and 80s matter to my life today?
Right. Like, why should I care?
But think about the intense political polarization we see right now. Look at the literal screaming matches happening at local school board meetings across the entire country.
It's everywhere. And the text provides a fascinating lens for that exact phenomenon.
How so?
Well, by removing transcendent order from schools, we actually exhausted our moral language.
Our moral language.
Yeah. because religious communities were historically the central organizations for civil self-governance. So pushing them out meant society had to find a completely new vocabulary.
Right. The text points out that we replaced words like sin, responsibility, repentance, and grace with like psychological and managerial terminology.
Yes, exactly.
We created an environment of, what did the author call it, weaker normativity and stronger therapeutics.
That's the quote.
Instead of talking about right and wrong in a moral sense, we talk entirely about behavior management and psychological comfort.
Furthermore, pushing religion out meant society became increasingly reliant on the state and the market to solve welfare and moral problems. Public schools were turned into what the author calls religion vacuum zones. And as we know, nature abhors a vacuum.
So something else rushes in to fill it.
Exactly. So now secular and religious groups fight bitter nationalized wars over every single local school board because the stakes have been pushed to a constitutional maximum.
There is no local compromise anymore.
None. It's all about controlling the state apparatus.
Okay, so we have covered the specific chain of precedents, and we have covered how the toolkit of expansive establishment and captive audience logic.
Right.
But we really have to look deeper to understand the why. Like, was this just a cynical power grab by a bunch of judges, or does this reflect a fundamental shift in modern human thought?
Well, the author brings in jurisprudence and philosophy to answer that. And the first conceptual shift driving this is living constitutionalism.
Living constitutionalism. That's the idea that the Constitution isn't a static document.
Yeah.
Right? It's a text that, quote unquote, evolves with the times.
Exactly.
Think of it like treating the Constitution not as a foundational anchor holding a ship steady, but as a piece of software on your smartphone.
I like that analogy.
Thanks. And the Supreme Court basically acts as the software developer, constantly pushing out updates and patches to match the spirit of the age or, modern sensibilities.
That's exactly it. And if you genuinely believe the Constitution is meant to evolve like that, then the court is tasked with being a historical legislator.
Right.
Judicial activism isn't an accident or an abuse of power in that framework. It is the logical, expected method.
Wow.
But the author goes even deeper to look at the psychology behind this, bringing in the political philosopher Eric Voegelin.
Okay, wait. Voegelin. He talks about Gnosticism, right?
Yes, he does.
Like the ancient religious heresy from the 2nd century. How does an ancient theology apply to a 1980s judge banning the Ten Commandments from a classroom wall? I'm a little lost on that connection.
It is a dense concept, for sure. But Voegelin isn't talking about the ancient cults. He uses the term modern Gnosticism to describe a specific modern structure of thought.
Okay.
It is the profound belief that humanity can create a perfectly purified, tension-free society purely through correct knowledge and institutional design.
A perfect society.
Yeah, it's this utopian belief that we can eliminate disorder, conflict, and even psychological discomfort from history if we just engineer the government rules perfectly.
So when the court attempted to create a pure public space, like a school, completely free from any psychological coercion or religious pressure, they were basically acting on this Gnostic impulse.
Exactly that. They subconsciously took on a redemptive spiritual mission.
Oh, wow.
They weren't just resolving a legal dispute between a parent and a principal anymore. They were trying to purify society.
That's a huge shift.
Voegelin argues that when courts try to create a completely neutral environment, they aren't actually eliminating order. They're just replacing one worldview with another.
Right.
The judiciary stops being a referee and becomes a new governor of souls.
Governor of souls, that is a heavy phrase.
It really is.
It means the law is trying to manage the spiritual and psychological environment of the nation rather than just keeping people from, stealing from each other.
Exactly.
And I think that bridges into the second philosopher the text leans on, Leo Strauss, because he observed a massive shift in how we think about the law itself.
Yes. Strauss points out that classical political philosophy operated in a natural law tradition.
Okay, so what did natural law actually look like in practice when a judge was making a decision back then?
Well, natural law meant the law was a rational inquiry into what is good and what is just for the public.
Okay.
It asked philosophical questions. Does this practice benefit the community? Does it align with a higher moral order? Does it teach virtue?
Right, big picture stuff.
But Strauss argues we shifted away from natural law and moved entirely into a rights discourse.
And rights discourse is fundamentally different.
Very different.
Instead of asking what is just and good for the community, the court starts asking purely procedural and psychological questions.
Exactly.
The question shifts from, is this tradition good for public education, to, does this historical symbol make a specific individual feel excluded or uncomfortable?
You've nailed it. Normative discourse, talking about what should be, becomes totally psychologized.
Wow.
Think about how religious liberty was classically understood. It meant protecting your physical conscience from state violence. The government couldn't throw you in jail for your beliefs.
Right, physical protect.
But under this expanded rights discourse, the right isn't just about avoiding state coercion anymore. It expands into the right to not be offended, or the right not to be surrounded by religious symbols you disagree with in a public building.
And when rights become the only language we use, we completely lose the ability to actually talk to each other about the common good.
Exactly.
Because every single moral disagreement just becomes a claim of a violated right. And if everything is a right, then the law has to constantly expand to manage everyone's sensitivities.
Which ties right back into the living constitutionalism we mentioned earlier.
How so?
Because historicism, the idea that meaning changes with the era, provides the ultimate justification for this expansion.
Right.
The court looks at the country and says, well, society is more diverse now, so we must rewrite the rules to manage these new psychological realities.
Wow.
The law loses its stable philosophical foundation and just becomes a mirror reflecting the current historical trend.
Okay, so what does this all mean? We've covered decades of legal history. We've talked about procedural versus substantive neutrality.
We covered Voidland's Gnosticism.
Yeah, and Strauss's rights discourse.
Yeah.
How do we pull all of this together to actually understand Kang's thesis?
The author's ultimate conclusion is that the true problem with the Supreme Court isn't about whether any single specific ruling on school prayer or the Ten Commandments was technically right or wrong in a vacuum.
Okay.
The problem is a massive structural shift in the nature of judicial power itself.
Right.
The common law tradition, which American law inherited, was supposed to be about the cautious, gradual, experiential repair of order based on practical reason.
Like the building inspector, just making sure the foundation is safe for the people living inside.
Exactly. But driven by modern Gnosticism, that desire to build a perfect, tension-free society, and a rights-based historicism, the court turned into an activist body.
They started engineering the house.
Yes. It began redesigning the spiritual and moral boundaries of the nation. When the language of natural law fell silent, the court stepped in to fill the void, reshaping public culture under the guise of an impossible neutrality.
You know, understanding this philosophical shift is just such a powerful shortcut to being truly well-informed.
It really is.
Because tomorrow, or next week, when you see a news alert pop up on your phone about the latest Supreme Court decision, you won't just be looking at the political outcome, right? Like who won and who lost the case.
Right. You can see the bigger picture.
You can ask a much deeper question. Is the court acting as a referee, resolving a specific dispute between two parties? Or are they acting as a historical engineer, trying to redesign the soul of society?
And it leaves us with a profound implication from the text to really mull over.
What's that?
If our legal system has entirely replaced the language of what is good and just with the language of what is my right and what offends me, is it still possible for a diverse, pluralistic community to ever agree on a shared moral foundation? Or are we destined to just keep taking each other to court, endlessly demanding that the state manage our psychological comfort?
Yeah, it really makes you wonder. If we keep demanding the building inspector redesign the house every time someone gets uncomfortable, eventually we might just forget how to live with each other in the rooms we already have.
Very true.
Thanks for joining us on this deep dive. Keep questioning the blueprints.